I'm sorry, Justice Thomas, and thank you.
What limits would you put on the Commission's authority to describe what a compelling interest is or what an extraordinary circumstance is?
Well, I don't think that they can simply disagree with Congress or authorize individual judges to
can they do
with
that?
Congress.
What I'm hearing is that in standing alone, they cannot disagree with Congress. That's what I'm hearing from the other side. But if it's a part of a totality of the circumstances inquiry, then they can disagree with Congress.
And I think the fundamental problem with that, Justice Thomas, is exactly what I just said, which is that it's a form of judicial parole. If you think back to what I said in the last case, essentially we are taking as a given that the other circumstances, the other reasons, are not in themselves something that would warrant a sentence reduction. They're not extraordinary and compelling enough. What gets them over the line is the fact that Congress adopted a non-retroactive change in law that it explicitly decided not to apply to prisoners in their circumstances, and that is what gets them consideration of these other factors that wouldn't be enough on their own.
So what do you say to the argument that it's not necessarily a direct attack, a disagreement with Congress, but rather the effects of the provision, the, say, for example, non-retroactivity?
Well, I think this is a direct attack on what Congress did because Congress drew a categorical line, and as the principal opinion in Hewitt recognized, that was partly to prevent all the relitigation concerns. I think the fact that, as my opponents acknowledge, these are even more burdensome to litigate than Section 404 adjustments to sentences, which Congress expressly did make retroactive, is a strike against it. When Congress makes categorical judgments and it wants to allow for exceptions in individualized circumstances, it will enact something like the safety valve, which for mandatory minimums, which it again adjusted. That's in Section 402 of the First Step Act. And here you have what the Sentencing Commission in 2021 estimated was 2,412 offenders with stacked 924C sentences who'd be affected if this became retroactive. And as I was just suggesting earlier, this is essentially a full retroactivity provision in the sense that it opens the door to things that were not extraordinary and compelling reasons suddenly crossing that threshold.
So, Mr.